Superannuation when you die is really important because increasingly people are holding an enormous amount of their wealth in their superannuation. So considering what might be within your super when you die is a really important part of the estate planning process. And that might not just be your member balance, for example, of superannuation contributions you've made during your working life, but also insurances that you hold in super that might be payable on your death. For many people, they often find that they have possibly millions of dollars in super when taking into account life insurances. So it's an incredibly important asset to factor in and make sure it passes as you intend when you die.
When you die, the trustee of your super fund decides who gets your super, unless you have in place a binding death benefit nomination that directs the trustee to make a distribution of your superannuation to a particular person or people.
The two different types of superannuation in Australia is self-managed superannuation and public offer fund superannuation. So for self-managed superannuation, it is as it sounds. It's a fund that you yourself manage and ordinarily only close family members are involved in. Typically there's only a few members. For public offer funds, they are funds that are available to the general public or in some instances to industry groups, and they often have thousands of members and have a trustee that is completely independent of the individual members who manages the fund on their behalf.
So there are pretty limited categories of who can receive super, and it will depend on the fund that you're a member of. So often the government-based funds are quite restrictive about who can receive super. But the main people for general purposes are your dependents, so your spouse and any minor children, so children under the age of 18.
Typically, your superannuation can only be paid to a small range of eligible dependents. So those people are your spouse or partner, your children, or your estate, being paid to your executor to be dealt with under your will. So it's quite important that people understand that those are the only eligible beneficiaries, and they plan for that when they are undertaking their estate planning process. We have seen instances, for example, where people have sought to nominate people who actually cannot receive their superannuation to get their super. So for example, siblings or friends, and those nominations would not be valid for their super. So if people wanted their superannuation to pass to those sorts of people, that's something where we would need to come up with a plan for their superannuation to pass to their executor under their will, and then for their will to reflect those wishes. The trustee of your super fund decides who gets your super. That makes it all the more important to ensure that you put documents in place to nominate where you want your super paid when you die, because you don't want to leave that decision up to chance. If you have a self-managed super fund, the trustee will be controlled by the members who you leave behind in that fund, and in some instances, they may not be the people that you want making that decision on your behalf. If you're part of a public offer fund, the independent trustee of that fund will make that decision. Usually that's a company that you have nothing to do with, and that is trustee of a very large group of, very large fund that often has thousands of members. So they're not going to have any idea about your family circumstances or anything. In order to make sure in both instances that the trustee does what you want them to do, you need to make sure that you put documents in place to nominate where your super is to be paid. And this is known as a binding death benefit nomination. A non-binding death benefit nomination is a nomination that you can make to the trustee of your super fund to let them know where you prefer your superannuation to be paid when you die. So you give them an indication of your preference. They take that into account, but they're not required to pay it out in accordance with that, so they may make a decision otherwise.
So there's generally a number of factors that need to be considered, but it's about usually the how much money is in your super account, the type of super, how old you are when you've passed away, how old your beneficiaries are, and the tax status of your beneficiaries as well. So generally any superannuation proceeds to a beneficiary under the age of 18 generally are tax-free, but it's usually worth getting at least your accountant or tax lawyer to have a look over everything to make sure everything's above board.
For other people who might receive your superannuation, for example, adult children who are not financially dependent on you, or people who receive it through your will, if your super has passed to your executor or administrator and then passed to beneficiaries, say through a will process or via your estate, then those people will generally be taxed on the concessional contributions that you've made to your superannuation during your working life. And that's because those concessional contributions were made before tax. So they came out of your pay while you were working before tax was paid. So there's typically then a top-up tax that is applied to those concessional amounts, so that effectively it's as though you'd paid tax on that money at the time.
Yeah, when you die, superannuation has to be paid out of your super. Super's a very specific tax structure. It has a very specific purpose. Its purpose is to provide for you for your retirement needs. That's pretty much it. So when you die, those retirement needs are no longer there, so it's a cashing event. It means that superannuation has to come out of your super fund and it has to go somewhere.
There's only one scenario where money might stay in your superannuation fund after you die, and that is if you've nominated a reversionary pension. A reversionary pension is when you yourself, at the time that you pass away, are in receipt of a pension from your superannuation fund, and you have nominated, which is permitted by the terms of your fund, to pass that pension to a particular super dependent, usually your spouse or partner. In that case, they receive your pension instead of you receiving it after you die, and that allows them to keep the money in the fund.
This is a question of it depends. Self-managed super funds may have individual trustees or they may have a corporate trustee. So if you are a sole trustee, if you are the individual trustee, your executor often takes over that role, steps into that role of trustee for a period of time until somebody more permanent can be nominated, or usually a company can be nominated. It depends on how many members there are, but I think what you need to understand is that somebody else will be making the decisions about that fund, and you've got to understand who that person will be.
Your self-managed super fund will be taken over by effectively the other members when you've passed away. So all members of self-managed super funds have to either be an individual trustee of the fund or a director of the company trustee of the fund. So whoever is left standing in terms of members will really control the fund going forward, because they will either continue as the individual trustees or as the directors of the company trustee.